My lords, my lady, my name's Dumont.
Yes.
I appear with my learned friend Mr. Edwards.
Indeed.
With the appellants. Mr. Giles Maynard Connor and Mr. Vice appear for the respondents. My solicitors Quinn Barrow and his solicitors Aaron and partners.
Well, I can tell you, Mr. Dumont, that we have read the skeleton arguments, including the supplemental skeletons.
Yes.
We've read the judge's two judgments, so we know what the points are.
Yes.
And the way that we would like to proceed is that we'd like to hear you first, and then at the outset of Mr. Maynard Connor's submissions, he can make his application to amend the respondent's notice, and then depending on the result of that, we will carry on.
I'm grateful. That's very helpful. What I was proposing to do was to take you briefly to the partnership deed.
Yes.
Although I'm sure you've read it. Also then take you through, I'm afraid, the judgment.
The first judgment.
First judgment, yes. And briefly the second judgment. And then elaborate on a few of the points we make in our skeleton. It's a relatively short point that is before you.
Yes.
I accept that, and I don't want to overplay the arguments. But we do need, in my submission, to go back to the judgment, even though you have read it, just to have a look and see what we say he said. And you'll see we've got three grounds of appeal. They overlap. I'm grateful, yes, they do. Let's have a look perhaps at the partnership deed first.
Yes.
That's at divider 21, if you have a paper bundle.
Yes.
I'm afraid if you've got electronic bundles, you will have appreciated that there is the sometimes common mistake in electronic bundles.
I think all three of us are old-fashioned enough to have a paper file.
What a huge relief. I wish I could say I was ahead of you there, but I am certainly not. Well, that's excellent news. We can
you don't have to do arithmetic every time you give us a reference.
It's quite simple arithmetic, I accept, but it's annoying. Good. That's very helpful. Divider 21, the partnership deed, you see the parties, just to mention at the time that Jennifer Morton, I probably will refer to them by their first names.
Yes.
It sounds awfully disrespectful, but it's the way that we always deal with it. It's the way the judge dealt with it. Jennifer Morton is called the first partner, so you know who is who. Simon is called the second partner, and Alison is called the third partner.
And this partnership, I think, was what the judge called the fourth partnership.
Yes, he did. Yes, he did. Simon Morton, he was born in 1958, so he's 65 now. He worked on the farm has been his life. It was his grandfather's farm as a tenant first. Father bought the farm. Son worked on it when he left school, went away to agricultural college, and came back and worked then. Was taken into partnership quite early, at age 25, and worked essentially up till 2015. He'd been working for 35 years on the farm. That was the context of the estoppel decision. If you look at the partnership deed, although it's 19th December 2012, the commencement date is the 1st of April at 1.3 of that year. There's a quick reference to 1.13 over the page, on page 284, Fair Oak Grange, which is a farm of 405 acres, which they were intending to buy, and then hence that was what provoked the parties to have a fresh partnership deed.
And that was also the trigger for Alison joining the partnership, I think, because
yes, it was.
Simon and Alison were together to buy the Staffordshire farm.
Yes, exactly. It also contained within it, unfortunately, it seems, the germ of the falling out, because it appears that Julie wasn't told that the farm was being bought, and she felt that things were moving away from her, that position, and that's where the tensions seem to have started, although one can never quite tell with these things. If you look at page 285, there's reference to the partnership freeholds. And there's one small point on that which I'll come back to, and you will have no doubt seen, that it is the named farms, the named properties, and all other freehold property registered in the names of the original partners, or either of them, in which they have a beneficial interest, which is presently occupied by them for the purposes of the old partnership. But the judge held that that specific description needed to be amended or needed to be construed to include the unregistered land, which was also owned and farmed with the partnership. At 1.17, we see a definition of an outgoing partner, and as you'd expect, it includes somebody who gives notice to terminate the partnership. The relevant accounting period, which we'll be seeing later, is the accounting period, of course, during which the determining event occurs. And over the page 121, the determining event is in relation to an outgoing partner, any of the events referred to in clause 16. One of those is notice. If you can move on then to page 289, where we see the provisions for account.
Do we need to notice clause 2?
Indeed. I'm grateful for that. And the terms can be varied by the unanimous written agreement of the partners. The bottom of page 289, we see an account should be taken on the account state in each year, but then without any revaluation of assets, subject to depreciation, or the dissolution of partnership as regards the partner after revaluation of the assets, as here provided, of the partnership's then assets and liabilities in a balance sheet prepared. So on dissolution, there's a revaluation. 15.1, partners declare that the following shall be and continue to be assets of the partnership freeholds, and the entitlements. Partnership freeholds, insofar as they are reflected in their respective partnership shares, will be credited or appropriated to them in the proportions in which they own such partnership freeholds beneficially, and in any dissolution, such beneficial interests shall be appropriated to their respective partnership shares. And that's, of course, essential importance in this case, because there was a huge imbalance in the way that they were credited in 2012, and it was that imbalance that was adjusted by His Honour Judge Halliwell's decision and order.
He inserted the proviso.
He did, exactly.
Did he draft that himself, or was that given to him, so to speak?
He drafted it himself, as I understand it. Yes, he did draft that himself. He had a few months to do so.
Yes.
Can I be sure I understand what the purpose of 15.1.2 is? In the absence of that, if the partnership freeholds was an asset of the partnership, none of the partners would have any claim to any particular asset. They would simply have a claim to an appropriate share of the partnership asset as a whole. And this enables the partners to claim that particular assets should be appropriated to their shares. Is that the purpose of it?
Yes, that is part of the partnership, purpose of it. There is another provision within the partnership which covers the way that the value of the properties are dealt with, which rather mirrors this one, and I feel I haven't. 19. I'm very grateful. 19. The price payable of the clauses 17 and 18 above shall be the amount standing to the credit outgoing partner on the date of determination. After this shall be the revaluation of the partnership's then assets. Not what I was thinking of. Well, if we find it, we'll find it. It's important in two ways, because one, it makes sure that the partnership shares are not equal but reflect the ownerships of the property, so that the properties are, as it were, separated out within the partnership capital shares. But it also means exactly that they are to be appropriated. Those benefits are appropriated to the selected partner shares, which will give them a direct link in with those properties on a dissolution. 16 is what a determining event is. And for this purpose, of course, it's 16.6, 3 months written notice having been given by him to the other partners to dissolve the partnership.
Just as a matter of curiosity, when we're looking at clause 15 about assets of the partnership, there's a reference to the freeholds. There's a reference to the entitlements, which means the payments under the CAP.
Yeah.
What about machinery, livestock, anything else that's used on the farm? Are they not partnership assets?
Well, I haven't seen a specific reference to them, but then to be honest, I hadn't got my eye out for them because that's not really what we're
just curious.
It's
Probably
curious,
it doesn't matter, but I'm just a bit odd.
It is unusual, yes. Partnership agreements are a hell of a thing to draft, but one might expect to see it.
Anyway,
the division of the partnership, perhaps we should look quickly at that. That's 8.1, profits and losses of an income nature of the partnership.
yeah.
Divided 50 to the first partner and 50 to the second and third partner. The net profits of the capital nature arising in respect of the partnership freeholds shall be divided between the partners in the proportions that they own in the partnership freeholds in question beneficially. So that's how their capital accounts will reflect the increased values. Good.
Yeah.
And when a determining event, page 292, and it's paragraph clause 17, when a determining event shall have occurred under clause 16 above, this is the option provision, the first partner, then the second partner, the third partner, equally, or the survivor of them, 17.1, and in this case, of course, it's the second and third partner. At 17.3, shall have the option exercised by written notice, given within 6 months of the determining event, the purchase by the end of such 6 months, the interest of the outgoing partner in the profits, capital, and assets of the partnership, immediately prior to the determining event, the purchase price being the value of such interest under clause 19 below. And just for your reference here, that if we look at under 17.3, the end of that first line shall have the option exercised by written notice given within 6 months of determining event to purchase by the end of the 6 months. But the next line or so, from 6, at the end of one line to the months at the end of the line, 2 lines, those are the lines which were deleted by the judgment of Judge Halliwell and replaced with the new provisions for timing to extend the option. 18, when exercising the options in clause 17, the option holder or holders shall indicate whether or not he or they wish to pay the price, paid by instalments. This is the instalment option. If such indication is given, pay interest, pay for the interest that imparted by 5 equal instalments, and first 1 year from the date of dissolution, and the next, obviously, annual instalments, and at base lending rate from time to time of Barclays Bank PLC. That's the interest rate provided for the instalment option. Price payable under clause 17 shall be the amount outstanding to the credit outgoing partner on the date, the determining event, after there should be a revaluation. We've already seen that particular clause. 20. Notwithstanding the provisions of clause 17, 18 above, there shall be paid to the outgoing partner by the remaining partners any undrawn balance to his share of the net profits of the partnership for the relevant accounting period. Such payment to be made within 6 months of the relevant accounting period. Interest on the undrawn balance or any part of it payable from the date of the due payment into the date of actual payment, again at the base lending rate of Barclays Bank PLC. So that's a separate liability to account of the shares in that accrued in that relevant accounting period or part thereof. So those are the specific terms in the partnership agreement I want to take lordships too. That then takes me to the judgment itself. And you can pick up the judgment. It says quite a long way in. There were a number of matters the judge had to consider. But if we start, we may have to go back a couple of times, but if you start at paragraph 189, this tells us what the estoppel, because it's the estoppel we're focusing on, it tells us what the estoppel, how the estoppel, as it were, arises. And that's page 182. In paragraph 189, we see, if we read 5 lines down, I am satisfied that the general scheme in the 1995 wills for succession to the farmland was consistent with the historic intentions of Geoffrey and Jennifer. This included in particular the provisions for the land to be treated separately from the other farm assets and given to Simon and Julie in equal shares, with Simon farming the land, subject to the payment of rent. That's rent to Julie, we'll see that later on. And a mechanism for him to buy Julie out. And we see that picked up again at 195, page 183. It says 1, 2, 3, 4, 5 lines up from the bottom. It is likely that Geoffrey advised Simon of the general scheme of the 1995 wills, in particular the gifts to himself alone of the farm stock and machinery, and the gifts of the farm land to Simon and Julie jointly, subject to Simon's right to continue the farm business, paying rent in respect of Julie's share, together with the right to buy her out at market value if Julie wished to sell her interest. And at paragraph 197, he repeats that again, but that he's about to get into his explanation of the estoppel at that point. So 197, we see, at the bottom of page 184, Julie confirmed in her witness statement that following Geoffrey's death, Jennifer advised Simon and herself about the contents of Geoffrey's 1995 will. I have no reason to doubt this is correct, nor indeed that Jennifer's advice was honest and accurate. And I'm satisfied that Simon was already aware that Geoffrey and Jennifer had made mirror wills in 95, providing that subject to their gifts to one another, there would be gifts of the farmhouse and Pheasant Lodge to Simon and Julie respectively. He'd also been aware in general terms that he would ultimately become entitled to farm stock and machinery, and whilst the remaining farmland was subject to a joint gift, he'd be entitled to farm the land subject to payment of rent, subject to Julie's undivided share, mechanism for him to buy out Julie if and once she decided to sell her share. On this basis, Jennifer confirmed and clarified the scheme of succession. So we have it from both parents. Both parents agree with it, both parents, as it were, buy into it, both parents make the representations. Then here we see the judge setting out, as it were, the constituent elements of the estoppel. We start with the assurances at 198 and 199. Consistently with this, I'm satisfied that Geoffrey repeatedly assured Simon that the farm business would ultimately be his. His assurances were tantamount to an irrevocable promise rather than a mere statement of intention. It was important to Geoffrey for the farm business to be passed on to the next generation of the family. To achieve this, he sought to encourage in Simon an expectation that it would be left to him. He made his assurances to Simon from the time Simon finished at agricultural college, if not before. Although it was at least implicit, the farm business would not devolve to Simon until after the deaths of Geoffrey himself and Jennifer. However, Geoffrey never regarded the land as a partnership asset. It's inherently unlikely he ever said anything to Simon to suggest otherwise. Moreover, Geoffrey and Jennifer were assiduous to advise both siblings that, so far as possible, they intended to treat them equally. In all likelihood, Geoffrey's assurances in relation to the land amounted to a promise. The land would be left to Simon and Julie equally on the basis Simon would be entitled to buy Julie's interest at market value. paragraph 200, we see that, again, he repeats 3 lines down. Jennifer was aware of the assurances and was content for Geoffrey to make the assurances on her behalf. Yeah. Over the page, she also known Simon would take Geoffrey at his word. Top of the page, 186. And rely on his commitments. Following Geoffrey's death, she took it upon herself to advise Simon and Julie. We've seen that already.
Then we 201 we get reliance.
Reliance and detriment. Yes, we do. Reliance. He acted to his detriment, working long hours, only modest remuneration for 35 years. And although he had a profit share, it did not fully reflect the extent of his work and contribution. At least initially, his drawings were limited. At the bottom of the page, had it not been for Geoffrey's assurances, it's unlikely he would have committed himself to the farm as he did. And when in February 2013, Simon co-purchased Fair Oak Grange, he did so again in reliance upon the assurances that he'd been given from Geoffrey's death, he'd inherit farming business, or at least a stock machinery in fourth partnership, and interest in the land farmed by him in partnership, including Jennifer's land. And that's a big decision, of course, Fair Oak Grange, because it involved a very substantial mortgage, borrowings, which Simon was to be liable for. And as to detriment, maybe we come and see it again somewhere later, but it's also clear that Alison herself suffered detriment in reliance on these promises, and that she gave up her career at Barclays Bank to work.
What's from 202?
You've got it, you got it. I'm delighted. Yep. And 202, the top of 202, I'm sorry if you've got ahead of me and I'm lagging behind, but it's the finding that given the length of the period over which Simon acted to his detriment in reliance upon the relevant assurances, the scale of the detriment was bearing on every aspect of his life and indeed the life of the rest of his family on the farms, it was unconscionable for Jennifer to repudiate the assurances as she did when she made the final will. Yeah. And
so then he comes to his conclusion at 205.
He does. Can I just take you to one more thing before we get to there? My lord, that it is significant that how this came about, and that he touched on that at 203. Simon and Alison were not advised the 2014 will, which had a 45-55 split of the land, or the final will, which Simon got nothing. During Jennifer's lifetime, it's likely Julie's role was critical in persuading Jennifer to make them. In doing so, she persuaded Jennifer to act contrary to the settled understanding on which Geoffrey and Jennifer had previously made their wills, without alerting Simon and Alison. And there are just a couple of other references to that, if I can just take you to those quickly. One is at paragraph 57.
Sorry, what paragraph?
57, I'm sorry, on page 139, the bottom of page 139, paragraph 57. 2 lines up from the bottom. In any event, I am satisfied on the balance of probability that Julie resolved to do what she could, so Jennifer to bring an end to the fourth partnership and make a new will with more generous testamentary provisions for herself at Simon's expense. She succeeded in achieving each of those objectives. In doing so, she undermined Jennifer's confidence in Simon. And the other passage which deals with that is in paragraph 193 on page 183. Yes. There are 3 lines down. In my judgment, it is likely Julie set out to persuade Jennifer to make the final will and succeeded in so doing. However, we have not elected to try and set it aside on the basis of undue influence, but the estoppel claim essentially gets one to the same end result. So,
where does the judge set out the terms of the final will? It's effectively all to Julie, subject to option.
Yes.
Not.
Yes. I'm afraid I can't give you that immediately, but we'll give you that later.
Yes.
Yes, so we got on to 205. Well, 204 is perhaps important just as part of the context. The decision of Simon and Allison, this is to serve the option notice, was made in a state of panic as the deadline for service approached without properly appreciating the potential consequences. They did so in the hope that they could thus ensure survival of their farming business, consistently with Geoffrey's and, of course, Jennifer's assurances. However, they now appreciate that they do not have sufficient funds to complete the purchase of Jennifer's share of the assets of the fourth partnership under the option, if calculated in the way the 212 partnership deed requires. If the option notice and the final will dictate Simon's rights of succession to the farms, they have no realistic prospect of saving the business. The farms will thus have to be sold, and family connection with the farms will be lost. Whilst contrary to Geoffrey's assurances and expectations on which Simon and his family farm the lands after 30 years, it's more than conceivable that this cannot be avoided within the parameters of Simon's equity. So that's, once the estoppel is granted, it still may not be possible. But, however, as the judge said, that is not a good reason to deny him the opportunity to avoid such an outcome. So, 205, I'm satisfied that Simon is entitled to an equity, binding on Julie in her capacity as executrix of Jennifer's estate under the doctrine of proprietary estoppel. To the extent that Jennifer's estate is unadministered, it also binds her executrix, as executrix of his estate. It is binding on Jennifer's estate on the basis that Geoffrey made the relevant assurances on behalf of himself and Jennifer, and so on. 206 is thus for the court to determine how Simon's equity can best be satisfied, guided by the minimum equity to do him justice, Crabbe and Aaron, per Lord Justice Scarman. I don't know to what extent you've had to look at guest and guest since it was decided, but you'll see that in fact we've rather moved away from the minimum equity to justice.
Well, we've emphasised the do justice part of it.
We have. We seem to have got to somewhere which is the maximum equity to justice. But if one still emphasising the justice. But anyway.
Guest and guest decides what it decides, and we're bound by it.
Exactly right. Exactly right. Then there's a reference to your lordship. The two alternative methods of achieving the outcome, namely giving effect to Simon's expectation or ensuring that he is compensated for the detriment. We also say that effect should not be given to claimant's expectation if it's disproportionate to do so. But Guest and Guest has now decided that that's if out of all proportion. It's a recalibration. He observed that if the detriment can be fairly quantified so as to compensate the claimant fully for the detriment, such compensation ought to remove the foundation of the claim. While he goes on to call this a compensation order, in effect it's a fulfilment of an expectation order. In reality, that's what he's trying to do. He's trying to ensure that the expectations are fulfilled, and in any event, after a 35-year period, one wouldn't expect them to actually to differ much. 208. In the present case, the farm business and relevant land are assets of the dissolved partnership. The partner is not entitled individually to proprietary rights over the assets. Their rights are governed by the provisions of the 212 partnership. Subject to the deed itself, the assets of the fourth partnership must be applied following dissolution in the order prescribed by section 44 of the Partnership Act. That is, paying debts and liabilities, partnership paying ratably what's due to partners for advances and capital, and dividing the residue between the parties in proportion to the divisible. In these circumstances, it is inappropriate to give effect to Simon's expectation by varying the trust on which the partnership assets are held. Simpliciter, however, it is possible to achieve a compensation-based solution, or effectively the same result, which reflects Geoffrey's assurances by adjusting the amounts credited to Simon and Jennifer owing to the introduction of partnership assets and extending the period to exercise the option so as to accommodate the adjustment. So that's how he's going to do it. On this basis, and there's more detail, Simon's equity is best satisfied by, and I've notionally inserted 1, setting aside the contract which came to being when Simon and Allison served the option notice. 2, extending the period for Simon and Allison to serve a new option notice under clause 17.3 of the 2012 partnership deed. And 3, providing the 2012 partnership deed to be construed subject to the following proviso. At the end of 1512, the 212 partnership deed, so the amounts to be credited or probated to Simon, Alison, and Jennifer, in respect to the partnership freeholds, when each relevant property was introduced to the fourth partnership. Simon will thus be credited or deemed to have been credited with the amount consistent with Geoffrey's assurances. So he does it by a rewriting of the partnership deed, which is now to include this proviso.
Yeah.
And you will have seen it.
Yes. Then he deals with tax.
Then he deals with tax, which he's dealt with because he feels he has to do the minimum equity to do justice. Well, that, be that as it may. Tax was not something he was actually addressed on, as I understand it, at the trial. This is him trying to work out what the consequences of his decision are going to be and fit that into his estoppel relief. For the avoidance of doubt, the proviso shall be deemed to operate with retrospective effect. This is significant, we say, from the commencement date as defined in the 2012 partnership deed, namely the 1st of April 2012. So that could be significant, for instance, for tax reasons, that interests arise then rather than later. But what he's done is he has varied that partnership deed, the contractual partnership deed, so that those obligations were taken on.
Then he explains why he's excluding the farmhouse and pheasant lodge.
He does. I needn't trouble you with that. I was then going to pick it up. Page 2018, sorry, page 192, paragraph 218, gives us an overview, if you like. Mm-hmm. Simon's share of the partnership capital is credited with half the capital value of the unregistered land, together with Fellwall land, registered, and so on. This will substantially increase his share of the partnership assets, the amounts to which he'll ultimately be entitled, if and when the dissolution accounts are taken. And he calculates that as 956,850 increase in the value of Simon's capital share.
Yes.
So that there's a value shifting, almost to the extent of £1 million.
Yeah.
And in paragraph 219 over the page, he again refers to Simon only entitled to minimum equity to justice and proportionality being taken into account. So it doesn't make any additional provision in relation to remaining partnership assets.
No.
220.
Then he goes on at 220 to extend
He does.
the option.
I'm satisfied that Simon and Alison should be given another opportunity to exercise their option under clause 17.3 to purchase Jennifer's shares of profits and capital. And he explains this on Geoffrey's assurance that Simon was entitled to buy out Julie's interests at market value. It's on the basis that each be equally entitled to the land. Under the 212 partnership deed, an analogous outcome could now be achieved by providing for Simon to buy Jennifer's share of the profits, capital and assets, the fourth partnership, under the provisions of clause 17.3, at a purchase price reflecting the proviso. In the exercise of my equitable discretion, I shall thus set aside the executive agreement to which the option notice has given rise and extend the period for Simon and Alison to serve a new option notice so as to expire after a period of 3 months. He fixes the date of commencement after any further submissions from the council.
Yeah.
So then we come to I suppose perhaps we'll deal with, just mention 225 in passing on 195. Subject to the 2012 partnership deed, the assets of the fourth partnership were and are applicable in dissolution in accordance with section 44 and calculating ratably what is due to her as executrix from Jennifer's share of the partnership capital. Julie's entitled to credit for the value of Jennifer's beneficial interest in the relevant properties upon introduction. Conversely, Simon is entitled to credit for the value of the interest induced by him. However, in each case, this is subject to the claim based on proprietary stock. And then he says he will make declarations he is, sorry, I should have noted, it's at the very bottom of page 193, we see the word 9, disposal.
Yes.
It's got to the disposal part of his judgment.
Yeah.
And we see there, 228, Simon's counterclaim based on proprietary estoppel. This is allowed to the extent set out, as we've seen above.
Yeah.
229, clause 15.12 of the 2012 partnership shows construed as if subject to the proviso. In respect, the amounts credited or appropriate to Simon and Jennifer from the partnership freehold.
Yes.
And more generally, he says at the bottom of that paragraph, the overall effect of Simon's credited money is respect of each of these properties which otherwise have been credited to Jennifer. I shall make order setting aside the executive agreement to which the option notice is given and extending the time for service of another option notice. And then 232, which is, we say, central. Simon Allison will continue to carry on the farm business since the dissolution of the fourth partnership, utilising its capital and assets without any final settlement of accounts. As Jennifer's executrix, Julie is entitled to post-dissolution accounts under the provisions of Section 42 of the Partnership Act, subject to the statutory proviso in Section 42(2), including a share of profits, and in the present case, an account of the use of Simon Allison has made of the partnership assets. She is also entitled to require partnership to be applied in the usual way in Section 39. So there, he's saying that her entitlement to post-dissolution accounts is subject to the statutory proviso in Section 42(2). Now,
I'm sorry, what you say it's subject to?
yes,
He is leaving open the question whether Julie is or isn't entitled under Section 42, isn't he? Because that issue is one that he recites in his order, is disputed, and he leaves it over to the second trial.
well, with respect, no. What he says there is that she is entitled to post-dissolution accounts. The only basis on which she is not entitled to them is because Section 42, which gives her the statutory right, is subject to Section 42(2), and he's saying there that her entitlement, therefore, is subject.
Well, it depends what you mean by subject. You're saying that he is deciding in this paragraph that
Yes.
Section 42(2) excludes Julie's right to profits or interest.
That is the effect. That is what he's deciding now. That is the effect of that paragraph. Because subject to, if what he's done is create a wholly new remedy under the doctrine of proprietary estoppel, then, and that's not a contractual option, then Section 42(2) has no possible operation. Right to account cannot be subject to Section.
Well, I understand that, but are you saying that he is deciding there,
Yeah.
in this paragraph,
Yes.
that the effect of Section 42(2) on the facts that he has
Yes.
found is to exclude Julie's right to...
Yes.
Right. Well, then why does his order recite...
His order recites that that's
in dispute?
in dispute. Yes, the other side don't accept that. Our view at that point was that you've already decided this.
Oh, I see.
The other side said, oh no, he hasn't.
Right.
And he made an order reciting that the other side didn't accept it. But we say the order itself also is based on the same premise.
Well, that was the issue that was then left to be decided at the second trial.
Well, we say that the order itself gave effect to the original judgment, and that had already been decided in the original judgment. We say it's consistent. You will have noticed. We say it's consistent with really every single time he deals with what he is doing when he grants relief, which is to adjust the partnership deed, to extend the option notice period, so it can be.
I understand.
You've seen all that.
But I understand that. But then that doesn't. As you say, it does does that necessarily determine at this stage the question of interest when Julie's side are disputing the effect of what the judge has ordered?
Yes, we say it does.
Right, all right.
We say it does, because otherwise, the words subject to statutory provisos in section 42 are inappropriate. If he is given a new option, which is not, and the only reason he's used those words is because the option he's given, he regards as an option under the partnership contract, which brings into play section 42 too.
What does he mean by the words including a share of profits?
Can I tell you what I submit he means there?
Yes.
That is a reference to the share of the profits in the relevant accounting period. That's why I took you to that particular, I think it's clause 20 of the partnership deed, that you're entitled to a share of the profits of the relevant accounting period in which the partnership was determined. So she's entitled to a share of the profits for that year, and she's entitled to post-dissolution accounts under the partnership deed itself and section 42, the Partnership Act, but to be overridden because it's subject to 42.2 if the option is exercised.
What do you make of the words "and in the present case an account of the use Simon and Alison have made of the partnership assets"?
She is entitled to an account until we exercise our option under the option provision. Section 42.2 gives her that right, but if there is an option and if it is exercised.
Yeah.
So we say he had in fact decided all these issues up to this point, consistently through his judgment, and then more specifically in this paragraph. And that when in the order recites, it's true that,
Yes, recital 3.
yep, claimant has elected to take interest, but her entitlement to do so is disputed by the defendants. Yep. She hadn't elected to take interest before that. That was it happened there. There was no previous entitlement to elect for interest which has been expunged or anything. This is where it happened, there and then, as it were. And then we look at the terms of the order, and you'll see that there's a standard order for dissolution. For some reason, in a partnership action, there's always a declaration of dissolution, even though it's obvious.
Yes.
Determination of disputed issues. The contract arising out of an option notice be set aside. So that was the executory contract, which had not yet been completed, was set aside. But, notwithstanding the express terms of the deed signed by the deceased partner and the defendants, 2012 deed, the defendant's option to purchase the deceased partner's interest in the profits capital of the partnership immediately prior to May 2015 shall be extended.
Yeah.
So this is the same option. This is the option we say in the partnership deed, but he's extended it because otherwise he couldn't operate the equitable relief he's granted. So it's exercisable, and then there's how he's tinkered with the wording changed the wording of clause 17, but we say it's still a clause 17 option.
Yes.
Notwithstanding any other provision of the 2012 deed, in the event that the defence exercise extended option, they shall pay the total sum which is determined, whether by agreement it's being due. These partners say the following instalments. So there's one instalment of 1.25 million, which is 3 months after termination, and then 15 months after termination the balance. And that overrides the 6th instalment option that is in the 2012 deed.
Yes.
But in fact, the 2012 deed is rather silent about how the option is to be fulfilled in any event. so probably needs some kind of directions about how that option is going to.
Paragraph 4 starts, notwithstanding any other provision in the 2012 deeds.
Yes.
He is overriding it.
Yes.
And clause 19, was it, of the partnership deed gave Simon and Alison the option to pay
Yes.
instalments, and here the judge is requiring them to pay instalments, and whereas the option talked about 5 instalments,
Yes.
the judge has ordered 2 instalments.
Yes. He has amended that option provisions. Exactly.
But it doesn't include any provision for interest on the second instalment.
No.
Whereas the instalment option in the deed did provide that there would be interest at, I think, Barclays base rate on the outstanding balance from time to time. Were these matters all argued out at the consequentials hearing?
Well,
We can see he handed down judgment in January, and there's an order in January saying there'll be a consequentials hearing.
Yep.
And then we get this order. So one assumes there was some argument on these matters. But
Certainly there were drafts of the order going back and forwards, and sorry?
My lords, I can assist you on that because obviously I
Yes.
think I may. The point was, my learned friend Mr. Edwards raised the point that the section 42 entitlement was disputed. My clients having no given notification as to the elections to the interest of the section 42, hence the recital number 3.
Right, your client gave notice after judgment.
After judgment that we were electing to take
Right.
interest. We were then told that the matter was disputed. It was briefly touched upon by my learned friend Mr. Edwards in his skeleton argument for this hearing. It was then, there was no substantial argument as to the points. The order was then framed by myself and my learned friend Mr. Edwards in these terms.
So it was the order that we are looking at tab 14
Yes.
was the process of back toing and froing of drafts. The judge was not asked to make any further ruling
No.
at this stage.
No, and you will have, as you're aware, he makes directions for the determination
Yes.
of the issue in trial 2.
yes.
There was some brief oral, I think, comments by myself and my learned friend at the hearing in April, but there was no determination, and the order was then agreed in these terms. I hope that's
Yeah, thank you.
Well, my understanding is that while that's as a general overview is accurate, that there were submissions about the timing in the for the instalments,
For the instalments,
and payment, so that there was some submission about
detail. Yeah, all right.
But what this order is intended to do is give effect to the earlier judgment.
Yes.
And
Yeah.
paragraph 5, account should be taken in accordance with general law, so with the provisions of the order. The assets and liabilities of the partnership and the effective entitlements of deceased partner and defendants. Particular account should be taken in the amount to be paid to the claimant by the defendants in the event that the defendants exercise the extended option. Notwithstanding any other deed or provision to the contrary, the rights and obligations shall be determined subject to the following. And then, so that's insertion proviso.
Yeah.
Then there's the point of tax, inheritance tax, capital gains tax, B and C.
Yeah.
And then there's some points on directions to the accounts and inquiries.
Yeah.
12, there's a here to determine accounting issues and other directions. And that at 12C, the extent, if any, to which the claimant is entitled to interest pursuant to section 42(1) of the Partnership Act 1890.
Yes.
So it hasn't been determined at this stage, but in his order, he hasn't taken any further steps to determine that, but we say it is determined in the original judgment and is given effect to by this order. And then we come to his second judgment.
Yes. We've read this one too.
Good. Well, page 207, he says what he's done, and you will now be aware, obviously very well aware what he said. Second line of paragraph 2 is remedies fashioned from the law of proprietary estoppel I made an award enlarging Simon's share in the assets of the partnership. I set aside the contract for the purchase of the share under an option in the partnership deed, extended it and so on, and made directions. And then paragraph 6, he said it was listed 3 lines down with a view to resolving the extent to which, having elected to claim interest under section 42 of the Partnership Act 1890, Julie Morton is entitled to do so.
Yes.
So that's the point he's now going to determine the election having been made. And we pick up the point at the bottom of page 210, paragraph 23. This takes me to the issue between the parties about Jennifer's claim for an account under provisions 42. Heading of the section 42 of the Partnership Act is as follows. He sets out the Act over the page, section 42.
You don't need to read all this aloud, do you want? Just
No.
the points you need to make.
Good. Paragraph 28. In the present case, the partnership deed did originally provide for the payment by instalment, so specific provision of interest. Of course, the contractual scheme was modified. And I say that gives us an insight when I gave judgment. I'm sorry, the proviso of section 42 is applicable to a statutory claim for interest where there is a contractual option. So he's got that point, right? Where there's a contractual option, section 42.2 applies. And the question is, does it apply where that's been modified? And we say, well, no, it's still a contractual scheme. The 32, in the present case, the dissolution notice operated to dissolve the partnership. On 8th of May, Sinus and then exercised the option to purchase Jennifer's share in the partnership by notice 26th of October 2015. The state entered a binding contract for purchase, interest, profits, capital assets. The extent necessary, the court would provide by implication the machinery necessary to give effect to the parties' contractual obligations, subject to Eggleton. Once the price payable has been determined, the court would no doubt be implied for completion to take place within a reasonable time. In the exercise of my equal jurisdiction, I made an order setting aside the contract under Simon Allison's notice, dated 26th October 15, and extending time with the service of another option notice under the partnership deed. And we say, yes, that's exactly what he did. But it's under the partnership deed, and that essentially decides the issue before him. Because if the option is a partnership deed option, then it comes within section 42.2.
Yeah.
On behalf of Simon Allison, Ms. Edwards submits to the defendant's client duly exercise the option. Due precluded from claiming an account. Also submits that it's precluded from claiming account because the option provisions in the partnership agreement amount to an agreement to the contrary for the purposes of section 42.1, at least in the case where the option is exercised. So there are two ways of coming at the same answer. Notwithstanding the skill with which Ms. Edwards' submissions on this issue are presented, I'm satisfied that Julie is entitled to a statutory account of interest. When I gave judgment, I did not disallow Julie's rights to a statutory account of profits or interest under section 42 in the exercise of my equitable jurisdiction. No, he didn't. She has a right, a statutory right, unless, we say, the option is exercised. And he obviously didn't take that away from her. Mr. Edwards is thus driven to rely on the statutory limitations of section 42 itself. Well, he's not driven to rely on it. We say that is where it goes. If he had dealt with it in a different way, if he had followed Jeffrey's assurances by granting a liability to pay rent, for instance, on half share, then that would have been a different approach. But that was not what he did.
I haven't quite understood, I'm sorry.
Yeah.
My fault. Paragraph 34, you said there were two alternative ways of getting to the answer, but I haven't quite understood the difference between them.
No, I'm not sure there is any difference between them, my lord. The judge seemed to think that there is a difference between them. If you look at section 42.1 of the Partnership Act, it says, where any member of the firm has died or otherwise ceased to be a partner, the surviving and continuing partners carry on the business of the firm. We can see back on page 211. Without any final settlement of accounts as between the firm and the outgoing partner in the estate, then, in the absence of any agreement to the contrary, the outgoing partner is entitled to the option himself. So there is an option. There is a provision within 42.1 about absence of agreements to the contrary.
Oh, I see. So it's either relying on those words in 42.1, that there's an agreement to the contrary,
Yes.
or it's relying on the proviso in 42.2.
Yes.
Yes, I do now see the difference. Thank you.
But essentially they come probably as So it becomes the same thing where there is an option. It might be in some cases where the partnership deed actually has a specific provision where requiring the remaining partners to buy out the outgoing partner. That would be agreement to the contrary, but it wouldn't be an option notice. So that it may be that that's the sort of thing that 42.1 is focusing on. The judge himself.
Well, also, I mean, if the partnership deed had remained in the original form, there wouldn't have been interest at 5%. There would have been a contrary agreement, interest at a rate tied to Barclays Bank, which is another form of agreement to the contrary.
That's the interest on the instalments.
Yes.
Yes. That would be another form of agreement. But then we would have already operated the option.
Yeah.
So that the right to an account and the alternative would already fall aside on that basis.
Yes. Right, so we got to paragraph 36.
We did.
And here the judge is distinguishing between contract and judicial remedy.
He is. But he's distinguishing contract and proprietary estoppel.
Yeah.
That's what he does there. He says the short answer to this part of the case is that once I set aside the contract under Simon Anderson's initial contractual option notice, an extended time for them to serve a new notice, the right to serve such a notice was based on the judicial award itself rather than the partnership contract. Well, we say that that's a misconception by him because, of course, they're still based on the partnership contract. The option is an option under clause 17, as he says repeatedly. But it's just that he has remodeled and reformed that in relatively small ways. The option still is the clause 17 option.
Does that mean that your argument would be different if instead of expressing himself as remodelling, to use your word, the option under clause 17, he had said, in place of the option under clause 17, I'm going to satisfy the equity by awarding an entirely brand new freestanding estoppel option. Then it wouldn't be an option under the contract. It would be something entirely separate.
No.
And your argument would be different.
Yeah.
Even if it had exactly the same practical.
Yes. Yes.
So is your argument really he chose to do it in a particular way
Yes.
that has this consequence?
Yes. Absolutely right.
Yes.
Absolutely right. It's the oddity about it is the consequence of the order, which he did not seem to foresee himself. And we say that
it sounds as if nobody really foresaw it. But you say what he did in January
yes,
was this,
yes,
and then it necessarily follows
yes, exactly. And
that section 42.2 applies.
Yeah, and that when he effectively,
and it's too late for him in September to say, well, I could have done it a different way, or I did do it a different way, because he didn't do it a different way. He did it that way.
Yes.
Yeah.
Well, you've got it. You got that point. Yes. And that's the point actually going on flogging our favour.
Conceivably, he might have been asked to vary his order under CPR 3 point whatever it is. If he said, "Oh well, I really didn't mean to do that at all," but nobody asked him to.
Well, he definitely did not do that. He has not said, "I made a mistake before. I got that wrong. I should have considered that in a different way." And if he had said, "Wait a second, I've got to revisit this completely," then we would have been in the position of arguing that as an estoppel-based remedy, what he should have done would be give effect to Jeffrey's assurances and the understandings, which were that there would be a rent paid for the half share, which will come in at about, a sixth or seventh of the interest figure. It'd be much, much less.
Is it because the interest rate figure is fixed at 5%?
That's what hurts so much. Yes,
Because presumably interest rates over the period were considered. I mean,
much less. Yes,
much less.
Malone Defendants has produced a calculation, which one's very grateful. But if it had been an interest at base rate, for instance, over the period up to his judgment, then it would have been about 1/10 of the amount. One could see, because interest rates were roughly sort of 0.5% or less.
Yes.
About 1/10 of the amount that's being paid out. And he has chosen a figure, well, his decision on this binary point, which arises afterwards, leaves us with the result that
It leaves you with a 5% rate, which is the statutory rate.
yes, it does. But it also leaves us with in the position that we couldn't afford to buy out, and therefore it was an unconscionable result because we didn't have the 950,000 value of the property assets. So those were shifted across to us so that we had a prospect of keeping the farm alive. But we got them bitten in the tail by this £725,000 liability, which he...
And I suppose if, to pick up my Lord's point, there had been a suggestion at the September hearing, oh, well, this wasn't what I meant to do, let's look at it again.
No.
One could then have had an argument as to well, if you're going to award interest as part of the estoppel, what sort of rates would be equitable?
Exactly. And one would have been talking about the market, one were trying to push it towards part of the bank race rate, which was the interest rate taken, which was chosen by the actual deed itself. And also would reflect the sort of money you might get on if you could put it in money on deposit. So it would have been that would have been a much more obvious rate. Absolutely right. But that wasn't the way it was dealt with. He did not say, I have the right to go back and change what I decided. He wasn't doing that. And arguably by the time he might not have had that right by that stage anyway. But that was not what he did.
No.
Instead he looked back and said, well, what actually have I done? To look at that, we look at the judgment, principally, say, but also the order which gives effect to it.
No, we have that point.
I'm grateful. The section, paragraph 36, I deal with this briefly.
Yes.
He says that judicial remedy is awarded under the doctrine of proprietary estoppel. It was based on principles separate and distinct from the law of contract. And he refers to Thorne and Major, the opposite. Basically, you have Hoffman, and Walton and Walton. I say this is really, we do not get the answer from what he's saying here about proprietary estoppel. It's quite true, and we entirely accept that in proprietary estoppel, you look back over the period. Contract, you agree at the outset what that's to be, and you follow that willy-nilly. The owl of Minerva spreads her wings and so on. But what we're looking at here is the relief that is given for proprietary estoppel. Not whether you think there is a proprietary estoppel, not whether the proprietary estoppel has grown and grown and grown to the point where it is a real thing which must be given. You're looking at the relief that's given. And the relief that is given, we say, on a proprietary estoppel, at the end of proprietary litigation, is effectively the same as the contractual. It's not distinct from the contractual nature of the partnership deed. It affects the partnership deed. It alters it, it modifies it, it amends it, it adds bits in, it changes it, but it's still, by its nature, has the same effect as a contractual deed. And it, going forward, that relief has the same operation and effect as the contract.
I mean, to try and put it shortly, whether there is a contract or proprietary estoppel will have a very decisive influence on A, whether relief should be granted at all, B, what relief, if any, should be granted. But once the judge has decided that I'm going to grant this relief, then you are looking at the relief actually given and not at some alternative relief that might have been given.
Exactly. And if you just postulate for a moment, imagine that this was one of those lifetime estoppel claims. It wasn't, because Jennifer died shortly after she dissolved the partnership. But if Jennifer was still alive if the judge inserts the proviso, which is his way of adjusting the capital balances under the partnership, that becomes a contractual liability, which Jennifer herself has. There's nothing in equitable estoppel which tells you that you won't be in the contractual world when you're looking at what the partnership contract is. So that's that point on estoppel. 37. Miss Edwards did not submit that Julie is precluded from relying on her statutory right to an account by virtue of the service of
Well, this is no longer an issue, is it?
No, it's not. And he says at the bottom, had this been a live issue, it's difficult to see how, following the unexplained delay up to 5 years and taking any new steps to complete the option silence, and can be shown to have complied with it in non-material respect. That's just a comment he's made. He's not making a finding that the option executive contract had fallen away, and in fact he had to set it aside in order to make way for the new one.
Yeah.
38. It was submissions rated 41 are based on the proposition that contractual provisions, including the option mechanism, amount or capable amount of an agreement contrary to the statutory right to an account.
Yeah, this is the same point, isn't it?
Yep.
Again, he makes a distinction between judicial function or function of judicial remedy rather than the deed. So it's the same point that he's made in 36.
Absolutely right. And we say no, there isn't that inherent distinction. But in any event, when you look and see what he did, it's quite clear that he did it. And just I mentioned already, but going back to paragraph 33, he extended time for the service of another option notice under the partnership deed. That's the odd thing about it. In the very judgment, where he's deciding whether this is the partnership deed, which is the options under, he decides it is there, and that would be sufficient for section 42 to be engaged.
Right. And then he comes to conclusion at 39, and then he goes on to other things.
Yeah, he says his conclusion, but that's no further.
Now, we've skipped over paragraph 26 in this judgment, which is a point that the judge decided in your favour.
Yes, we have.
It's a point Mr. Maynard Connell revives by way of respondent's notice. Now, I don't mind whether you deal with it now or later, but don't forget, deal with it.
Well, we deal with it in our scope of an argument, and we said that pretty comprehensively there. Just to make a couple points on that. Lindley and Banks favours Ms. and Friend's view. Blackett, Oldenharen favour my view. Just to make the point about Lindley and Banks, that's not Lord Lindley saying that.
No.
It's a much more recent.
I'm not sure there's a great deal of difference between the two of them, to be honest. Because what the editor of Lindley says in a footnote is that if you've got an option, then there's a necessary implication that excludes it. So.
Yeah, quite. And also, there's a slightly complex argument, complex to me at least. If we look at the last few words of 42.2.
Yes.
Can I ask you to glance at that? You'll see it on page 211, so
yes.
You've got it immediately in front of you. It says, 4 lines up from the bottom, if any partner, assuming to act and exercise the option, does not in all material respects comply with the terms thereof, he is liable to account under the foregoing provisions of this section. Now, that means that under section 42.1, there's a duty to account, and the outgoing partner has the option of choosing an account or interest. That's then overridden by the option being exercised by the outgoing partner, by the continuing partners. So assume, therefore, that, as happened here, Julie says, I will want to take a interest. We then say, we're exercising the option, you can't have it. We then fail to proceed as fast as we should. Apparently, my cousin would be liable to account under the foregoing provisions, which appears to mean liable to give an account of profits. So we wouldn't go back to the interest option, we would be having to go back to the accounting option if a liability to account has a limited meaning. If liability to account just means, is shorthand really for liability to account for profits or give the alternative interest provisions, then that ridiculous outcome would not happen. So we say that those last words make it clear, if any clarity is needed, that when we're talking about liability to account, one's including within that liability to account the 5% interest option if that's taken by the outgoing partner. It is a simple alternative. Given to avoid the misery that is often brought on the estates of outgoing partners of having to try and obtain an account from the people who are going on running the business. That's not somewhere you want to be. It's an alternative. And once the alternative doesn't survive if the liability to account has gone. And in any event, section 42.2, the final words, shows that liability to account is they're talking about both interest and the actual pure liability to account.
Well, I see the question, if it arises, whether he is liable to account under the foregoing provisions, means he's liable to account for profits, or he's liable to account for profits or interest at the option of the outgoing partner. But I don't think I've quite understood what your submission is that the better view is.
I'm sorry, my submission is that those last few lines show that the entire liability to account, which includes the option of taking 5% interest, revives when
if you fail to comply with the option, suppose you're right on the general effect of 42.2 of excluding the rights under 42.1. But you fail to comply with the option in all material respects, then something revives. And your submission is what revives is the whole of 42.1, including the option to opt for interest in lieu of profits. Is that in dispute?
Yes.
To put it in reverse, so to speak, you say that section 42.2 means that if you do comply in all material respects with the option, you are not liable to account, quote, under the foregoing provisions of this section.
I was groping, but perhaps I wasn't even groping towards that sort of submission. But yes, that's exactly how I was. That's what I'm trying to say.
Now, you do, in your skeleton argument, in urging us to refer Mr. Blackett-Ord's view, rely to some extent on Williams and Harris, which is the Irish case.
Yes.
Which Mr. Blackett-Ord quotes as saying that there's no jurisdiction to award interest on an option. The problem is it wasn't an option case.
That is a problem. It's not an option. You're quite right. I've now read the case, and it's not an option case. But what it is a rather throwaway remark. But what is clear is that in that case, it's a contract case. And the contract overrides.
Right. The point was that the continuing partners were trading with their own assets.
On
the true construction of the partnership.
Exactly, because they've been a contract. Exactly. But that is, in a sense, what happens when you've got an option. But once you exercise the option, the liabilities are all determined by that option and its exercise. And there's no room for an account. But you're absolutely right. The Irish case is not directly on point. principle is the same.
Yes. Right.
Good. Well, I hope that within the submission I've been making before you today, I have made all the submissions I was intending to make by reference to my skeleton. They're all in there. And if I think of any that I have missed, I shall try and badly get a chance to say them later.
As though we're going to need the full day and a half then?
No.
Even the full day.
No, but that's no surprise with our panel.
Do we need to draw a distinction between your three grounds of appeal? You've argued them all together, in effect.
Yes, I have. They, in a sense, they have a logical separation, but they do very much overlap. We've tried to look at it in three different ways, but really, you can't separate them out.
It's the same point.
It is the same point. Yes. I'm very grateful.
Thank you. Thank you very much, Mr. Dewar. Yes, Mr. Maynard.
You've asked me to move my application to amend first.
Yes.
You will have seen the substance of the application is to introduce a new ground into the respondent's notice. That in effect, if you are with my learned friends with respect to section 42, that in any event this court should exercise an equitable jurisdiction toward interest. And that's either at the 5% or, if you are not happy with that, at some other rate. Now, I make it clear that from the outset that I say, and I say that this has, and I say respectfully, this has real force to it, that you should not only allow exceeds in that application, but in the bare minimum, interest should be awarded at the rate that was under the partnership deed.
Yeah.
Because, in effect, and this was a submission I was going to be making to my lords and my lady in any event, but I've heard the judicial comments already this morning, that if you are right, if my learned friend is right, then what in effect has happened, whether or not it was intended or not, but what in effect has happened is that a new payment by instalment option has been created by the judge.
Yeah.
And what we have is a situation that Simon and Arson have now got an instalment payment, the first of which kicks in 8.5 years or thereabouts after the option was exercised, and then the second another 12 months later. And they had agreed that if there was going to be an option, they should pay at Barclays Bank base rate.
Can I just step back a moment, just look at this in rather more formal terms?
Lord, yes.
If Mr. Dumont loses his appeal, you don't need this point.
No.
So the premise underlying this point is that Mr. Dumont wins his appeal, and we set aside the judge's declaration that Julie is entitled to interest under section 42 of the partnership.
Yes.
In those circumstances, you are asking us to make a different order from that which the judge made, declaring that Julie is entitled to interest under the equitable jurisdiction, I suppose, either at the rate of 5% or at some other rate for us, or perhaps the first instance judge, to determine. But the first procedural problem I think you have to overcome is that where the respondent wishes to vary the order below, you need to apply for permission to appeal. So this isn't simply a case of applying to amend a respondent's notice to uphold the judge on the grounds that he gave, or indeed different reasons. It is in fact an application for permission to appeal. And that's made clear by paragraph 8 of Practice Direction 52C. Now, on one view, it's an appeal against, or application for permission to appeal against the judge's second order. On another view, it's an application for permission to appeal against the judge's first order, because that is the order in which he exercised his equitable jurisdiction. In his second order, he did not, nor was he asked to, exercise any equitable jurisdiction. So, at any rate, on one view, you are applying for permission to appeal quite a long way out of time.
Well, my lord, you'll have seen how we've addressed this in our supplementary skeleton. We say that the court has powers we are seeking a variation.
Yes.
Insofar if the appeal succeeds. We say this court has power to deal with that. If I get the relevant section, section B deals with the application to deal with that. And we say that you have
Section B of
our supplementary skeleton. We say that the court has jurisdiction to do that because this is consequential on the successful appeal. In the event that the appeal is successful, that you have the power to vary. Now, we referred to the SP and Houston case. Now, my learned friends say in that case there was an appeal against an order, and the court varied another provision of the same order, notwithstanding that there was no cross appeal. My Lord, with respect, I suggest that I'm not actually in the territory of a formal permission to appeal application. We are seeking a variation, but we are asking the court to exercise this order and the power that you have, to exercise the power that you have to make that variation. Now, we say the power that you have to do that is squarely provided by Rule 52.20(1) of the CPR.
(52.21).
52.20 brackets 1.
Yes. Yes, and 2A says we can vary an order, but that's what we can do. That's not. Is it to do with how you ask?
Yeah, we are asking you to order the September order. We are saying we do not need to appeal the April order, and because what in effect has happened is, if this appeal is right, is that there has been an unforeseen consequence that was unforeseen by anyone, including His Honour Judge Halliwell, that if this is not dealt with, is going to result in a grave injustice as far as Julie is concerned. I mean, I need to take you through the application if I may, but we say that you do squarely have the power to do that. Even if we're wrong, we say, and we would accept, as we do in the supplementary skeleton, that usually the Court of Appeal would not deal with matters that haven't been properly dealt with below, and I'll address you with that in due course. The court can deal so in an exceptional case, and we say this is an exceptional case. If, though, you're completely against me and I'm on Denton-type principles, then taking them into account, is there a serious and significant breach for not seeking permission to appeal below? I will say no, and I will explain why I do so in due course. Is there a reason for the delay for the breach? And we say yes, and we'll explain that. And then, but in any event, we say in all the circumstances, it is right that the relief from sanction, or the permission, should be granted to deal with this at this stage, in order that the issue of interest can be properly dealt with. In the circumstances where, and I say I have to disagree with Mr. Dumont on this, Judge Halliwell he may have inadvertently made the option that my learned friend is arguing for. I say he didn't, but that was not his intention. And he was not intended to make any order that expunged the rights that Julie had already accrued under the statute by the time we get to trial 1. Now, my Lord, if I may, and I'll deal with, I'm conscious of the procedural matters, but before I deal with that, can I just pick up on some chronological facts that my learned friend, I make no criticism, but my learned friend has not picked up on during his submissions this morning.
Yes.
The first, and you've probably got this, but we've not looked at the document, and I'm not sure if you've seen it. But if you, and that is just to be clear, you saw the partnership deed, and it is clause 18 that gave the right to acquire by instalments and with interest at Barclays Bank lending rate.
Yeah.
The notice to acquire you haven't seen, but that is at 299.
Yes.
And that did not exercise the rights under clause 18. So Simon and Allison did not have the right to pay by instalments. They had to purchase, therefore, in accordance with clause 17, and the partnership deed in that regard, you will see clause 17, you've already got it, but I'll give you the page reference, is at page 292, and that required the purchase to be at the end of the 6 months. Now, that is important because, as a matter of fact, there had been no compliance with the requirement to purchase by the time we get to trial 1. Remember, the chronology is the notice of dissolution is January 15, the date of dissolution is May 15, the option notice that we've just seen is October 15, Jenny dies in September 16, probate is obtained by Julie in July 18, the proceedings are subsequently brought, and we go before the judge in the summer of 2021, and that's when trial 1 takes place, and he makes his order in April 2022. So, and I'm not getting into the blame game at this point, I don't need to, we say, but as a matter of fact, there had been no compliance with the option.
Yeah.
Can I ask, the option requires the purchase price to be the value of the interest under clause 19. Clause 19 requires there to be a revaluation of the partnership's assets. So until that happens, you can't actually pay.
No, and
so saying you've got to pay within 6 months of giving the notice doesn't actually work because you can't pay until the amount's been estimated.
Well, it does in as far as you expect. If you say if you want to do this, you've got to get on with it, and you've got to have the valuation determined quickly so that you can buy within the 6 months. I mean, it is not a very well written agreement, as we've seen, but it's squarely the only right to pay by instalments is that given under clause 18 over a 5-year period, but subject to interest.
Yes, but put on one side the right to pay by instalments, because as you say, they did not opt in their notice to pay by instalments. So you're left with just clause 17.3. It says it has to be paid within 6 months, but what you need to pay is the amount determined under clause 19, which requires a revaluation, and I assume there never was a price determined under clause 19.
There wasn't a price determined.
So they never got to the stage of having to pay. Is that right?
Well, Lord, I don't
You don't accept that.
Because it would have to be implied that would take place within a reasonable time.
What would have to take? I understand entirely. You'd have to. And the judge says this, and I think in one of his judgments, I think the second one, that once the price has been determined, then you have to pay within a reasonable time thereafter. But whose obligation is it?
I think he says the mechanism would need to take place within a reasonable time. I can give you. I would argue that it must have been implied that the determining, given that the overriding provision is to purchase by the end of 6 months, if there's going to be a determining event that's going to go beyond that, that's going to have to take place within a reasonable time. It can't be said that you can wait 8 years and for whatever reason avoid the obligation because there's been no determination in the meantime.
But it might depend whose obligation it is to procure a revaluation and things like that. I mean, these are not issues that were debated or decided, and they're not issues that now arise in the sense that the judge has set aside that contractual mechanism. But you are inviting us to proceed on the basis, Simon and Alison were in breach of contract in not paying under that when the contract was still in existence?
No, there was a contract to buy, and we are saying that there was a failure to comply it's really the effect of section 42, because 42.2 says that if there is an option, then if any partner assuming to act in exercise of the option does not in all material respects comply, he is liable to account under the following provisions. And of course, my learned friends say, well, that catches both interest and the account. And what I am saying is, it is unarguable that there was a failure to comply in all material respects with the option contract that had come into existence in October 2015. So by the time we get to trial 1, Julie had statutory rights under the Act that, in effect, my learned friends are saying were expunged as a result of the order that was made in October. And we say that that's very important. Now,
does that submission require us to decide that before the judge set aside the contract, Simon and Alison were in breach of contract?
No. All you have to be satisfied is that there was a failure to comply in all material respects.
Was that not the same thing?
Well, there were. I mean, I do say that they had breached because there was when you look at the deal, it cannot be said that there was a failure to. There was no purchase. We were 7.5 years later. There was and that is enough, I say, for that exception in 42.2 to apply.
So you say, when you exercise an option like this,
Yes.
there comes into existence a contract to buy.
Yes.
And although time is of the essence of the exercise of an option, time is not of the essence of the resulting contract if the option is duly exercised.
Well,
I think that's right.
Clause 17, yes. Clause 17.3 says the 6 months, but then it's subject to the determining event point.
Yes. Clause 17. Yes, you've got to buy at the end of
the 6 months.
At the end of the 6 months, but time is not generally of the essence.
No, it isn't.
Such an obligation. You can, of course, make time of the essence by notice, but nobody ever did, as far as we know. There is an obligation to pay interest under. Well, there would have been an obligation to pay interest, I suppose, under Clause 18 had that option been pursued, but it wasn't. Although what the outstanding balance would be, in the light of my Lord's question, is rather more difficult to know. On what sum would the interest be payable?
Well, that would be, under Clause 17.3, that under Clause 18, that would be the price referred to in Clause 19. And it is that sum that is to be paid by 5 equal instalments.
Yeah, after the revaluation.
After the revaluation, and and obviously the outstanding balance from time to time. Presumably, it's that on those instalments you pay interest is accruing on the amount that's been determined until the first instalment is paid, and then.
No, I follow that, but until you've had the revaluation, you don't know what the outstanding balance is.
My lord, you don't. It is not a very, as I say, a very well worded provision at all.
Is it implicit in your argument? But it was Simon and Alison's obligation to procure the revaluation, as opposed to Jennifer's and then Julia's. Because the partnership doesn't actually say who is to procure the revaluation. It just says there shall be a revaluation. It says accounts will be drawn up and they'll be on a historic basis, except if there's an outgoing partner, and then there'll be accounts drawn up on the revaluation basis. Normally, I think, when somebody leaves a partnership, the authority of the partners all the partners continues for the purpose of winding up the partnership business. So they could all have given instructions to the partnership accountant to revalue the assets. So
Well, I think it's clause 26 has the valuation. Surveyor. Any valuation required determined by a surveyor on the application of any of the partners by the president of the RICS.
What I would say is, it is Simon and Alison who are seeking to benefit from the exception in 42.2.
yes.
Yes, they are the ones that say we have an option, and whilst that option is being complied with, we don't have to pay interest should you elect to do so, and we don't have to account for profits. So they are under a very clear obligation to ensure that the option was complied with, including obtaining the determination of the valuation, and they failed to do that.
So you say that the 6 months, which they have to pay within the 6 months of the determining of giving the notice.
No,
6 months of a determining event. So they give the notice in October, but they have to comply with it by May, I think.
No, the determining event is the dissolution date on the 8th of May.
Yes, so
the 6 months would have been towards the end of October. Now they serve their option right at the end. What should have happened was they should have served the notice earlier on, got on with it, and had the value determined and purchased before the end of the 6 months.
So your submission is it's implicit in this structure that you can only duly comply in all material respects with the 17.3 option if you've not only given the notice but procured a revaluation, got the answer, and paid the money.
No,
within
I'm not
6
saying.
months. You're not saying.
I'm not saying that. I'm saying the clause seems to envisage, as drafted, and I accept it badly worded, that everything happens within the 6 months, because it says you have a right to buy within the 6 months, but of course it's subject to determining the value. So the deed appears to envisage everything happening within the 6 months.
Yeah.
Practically, one would assume that that's going to be very difficult. So I'm accepting that the actual determination potentially goes beyond the 6 months, but I'm accepting it must be within a reasonable time, and that would be implied into the deed. And I believe that that is the mechanism that was envisaged by the judge. That, I think, is, if you look at page 212 of the bundle, and I believe it's paragraph 32, my learned friend has just...
Sorry, are we in the first?
It's the first judgment, my lady.
Could you give me a paragraph number, please, rather?
Paragraph 32.
Second judgment, I think that is.
Sorry,
Second
second judgment, I'm sorry.
Page 212.
212.
Well, the last sentence of that was what I remembered. Once the price has been determined, then a term should no longer be implied
Within a reasonable,
within
yes,
a reasonable
you're
period
right.
of time.
Yes, you're right to say that. But
But he also does say the court would, if necessary, provide machinery necessary. I understand all that. But the court doesn't actually need to imply anything, because, as my lord pointed out, clause 26, I think, of the partnership deed gives any partner the right to require a surveyor to be appointed to carry out a revaluation. So it would have been open to Jennifer, once the notice had been received in October, to say, well, I want to be paid as soon as possible, and give instructions to a surveyor to get on with a revaluation. I'm still slightly unclear whether your argument depends upon it being the duty on Simon and Alison, as opposed to Jennifer, to procure the revaluation.
Well, I accept my Lord Justice Lewison is right in relation to clause 26, but Simon and Alison are the ones that are seeking to rely upon the exception in section 42.2. That says
They're the ones that want to buy.
But they're the ones that don't want to pay interest or account for profits.
Yes.
And the only way they do that is by complying in all material respects with the option. Yes? So...
Yes, I think if I've understood, tell me if I'm wrong, but I think your submission is this. They have to comply in all material respects with the option. The option obviously implicitly requires them to pay the price within a reasonable time.
Yes.
That requires them, if they want to do that, to procure a revaluation if no one else is doing it,
Yes.
and get on and get to the figure so that they can pay.
Yes.
And they didn't do any of
They
this.
didn't do any of that.
I think I understand the way in which you put it.
I'm grateful you've explained it more eloquently than I.
Well, I don't know about that.
But that is right. So we say that as a matter of fact, there had been a failure to comply with all material respects. And so therefore, Julie, by the time we came to trial 1, Julie had accrued rights under section 42. She hadn't made her election at that point. She makes the election after the judgment in trial 1, but she had accrued statutory rights.
If Simon and Alison had taken steps to procure a revaluation of the assets, the revaluation would not have included with it the adjustments that the judge made to the allocation of assets.
Well, I mean, this is one of the. It was actually, in the end, it ultimately was the matters were brought forward because Julie was positive, and she took the positive steps to bring the claim. Simon didn't bring a claim.
No, I follow. But am I right? You say, as I understand it, in answer to discussion with my lord, it's Simon and Alison who have to comply with the option in order to take the benefit of section 42.
Yeah.
The option contract requires them to pay within a reasonable time. Yeah. If they wish to take advantage of section 42.2, they must take steps to put themselves into a position in which they can comply with the contract formed as a result of exercise of the option.
Yeah.
That in turn requires them to apply to the president of the RICS for the appointment of a surveyor to carry out the revaluation. Had they done that, the revaluation would it have included the adjustments to the assets made by the judge as a result of his acceptance of the proprietary estoppel claim?
It wouldn't. I'd have to accept that because the Simon's equity that has been established would not have been established at that point. But Simon did not initiate the proceedings to get that matter resolved. Yeah. Simon and Alison were quite happy to sit back and enjoy the benefit of the assets. And it was Julie, on behalf of the estate, that took the positive steps to procure the issues to be determined. The next point is a matter of fact, and you've seen this is dealt with in the submissions, but the list of issues that were agreed for trial, and this is important when we look at what the judge actually did.
This is for trial 1.
Trial 1 did not include the question of interest, whether under section 42 or under the equitable jurisdiction. Now, I remind you of what the Supreme Court set out in the San Suu Kyi case. We've given you the relevant reference, but it's paragraph 13.
It's Lord Sumption.
Lord Sumption. And it's the words right at the end of paragraph 13, in which he says, in particular, the interpretation of an order may be critically affected by knowing what the court considered to be the issue which it was supposed to resolve.
Right, just a minute, I'm behind you. Tab 8. Yes. San Suu Kyi, right, looking at San Suu Kyi, paragraph 13. Yes.
And it's paragraph 13. It's right. It's the bit right at the end.
Yes.
Now you've heard from Mr. Dumont this morning that he says when we look at paragraph 232 of the first judgment, the judge has made an order which, in effect, has granted an option that has impacted on Julie's rights under section 42. And we say, no, he didn't. It wasn't an issue before him. It is common ground that he heard no argument from either myself or Mr. Edwards about it.
Do we have the list of issues for trial?
We have the agreed list of issues for trial at 123 to 124.
all the lists, all the issues on the first page are not dealing with the estoppel. They're all what happened otherwise, and then the estoppel starts is just 12, really, isn't it? 12 and 14. Do they have an entitlement?
And as to remedy,
What declarations are appropriate?
yes. And of course, when he makes his order, what does he do? He says, well, I'm going to determine section 42 in the next stage. Of course, there's no split trial here. We are in one process that just happens to have 2 stages to it.
Well, it's very common in partnership actions to have counsel inquiries.
Yeah, for sure. Now, so we say that that's important when one's interpreting the order.
Sorry, just help me on paragraph 12 of the list of issues poses what appears to be a single question. Do they have an entitlement to all the properties as a result of proprietary estoppel? The judge didn't find that. He found something different.
Their
And
primary
as to
claim
remedy, what declarations are appropriate doesn't, on its face, link in with paragraph 12, because it's talking about the terms of the partnership, the extent of its assets and the party's interests. So the judge does seem to have gone outside the very narrow confines of the issues as framed, doesn't he?
Well, my lord, firstly, and I'm going to pick this up in the judgment,
Yeah.
the primary claim was to all the properties,
Yeah, I follow, yes.
apart from Pheasant Lodge.
Yeah.
So that's why 12 is there.
Yes.
On 14.1, I think it's the relevant words and the party's interests.
Right.
So that includes interests arising from estoppel.
Yes. That's definitely how, I'm not giving evidence, but I think it's fair to say that's how myself and Mr. Edwards understood it.
Well, it seems to be how the judge understood
Yes.
it, because he went on
To deal with it.
to deal with it.
Now, if I may just quickly pick up on the judgment, because obviously this is relevant to what we say is the all the circumstances of the case, and that it is you would lead to a just outcome or an outcome that was a grave injustice as far as Julie is concerned if she gets no interest.
This is Denton stage 3.
Effectively, yes, but I'm just picking up on some points, and I'll be very quick on this. Of course, this is Judgment Trial 1.
Yeah.
So my learned friend addressed you by, as you went through it, showed you the comments about Julie at paragraph 57.
Yes.
I don't believe he picked up on the point at 58. He said he wasn't making a claim for undue influence. In fact, if you look at paragraph 58 on page 140, the judge found that there were no grounds for Simon to challenge the will by undue influence or fraud. That's the last sentence. You will have also picked up, and the relevance of this, I say, underscores why there should be interest as opposed to an account of profits, which my learned friends have suggested as an alternative in their supplemental skeleton, is that, of course, Simon's and Alison's case was much more extensive in its scope than that was ultimately succeeded. And you've read Trial 1, and you've seen that a plethora of arguments, including rectification, failed, but also that it was expressly found that Simon had given knowingly false evidence. That's paragraph 65 on page 142. Even as far as paragraph 68, he'd suggested expressly, it was recorded to his discredit, that Jennifer had been involved in some form of conspiracy to do him out of his share of the farm, which was rejected. Alison's evidence was tainted by the way in which she effectively supported and replicated that given by Simon. and that's recorded at paragraph 71 on page 144. The point about them claiming all the property, save for Pheasant Lodge, was recorded at paragraphs 86 and 87 of the judgment. And you'll see there, that's on page 148. And they wanted a transfer to them on terms of the entirety of the land farmed under the forfeit partnership as the minimum relief necessary to satisfy the equity. 142 was a finding in relation to the failure to exercise the option.
Yeah.
And you'll see there the judge was satisfied that the explanation was that they were well aware that they were unable to raise sufficient funds to purchase the share of profits, capital and assets. 143, and this is important. It's the end. We see it later, but when he's dealing with how to deal with the option, he says at the end, "I'm satisfied that through the service of the option notice, Simon and Alison entered into a binding contract to purchase." Now, we say that that is important because, of course,
Sorry, where are you?
that's at the end of 143, my lord.
143. Yes.
Yeah, there was in fact there was no longer an existing option to purchase. There was a contract in place, and that was set aside, and it was a new option was awarded by the judge. This wasn't a variation of the existing option. That option had gone. It had become a binding contract. And we know that that's subsequently set aside. The references there are 220 and 230 in the judgment. We've seen those. I then just need to pick up on paragraph 232, which my learned friends rely heavily upon. And it is said that the judge, it's confirmed by Mr. Dumont this morning, determined the issue in this paragraph. And we say that is respectfully incorrect. The paragraph 232 is on page 196.
Yeah.
The judge was not making a determination. He was recognising that Julie had rights under the section 42, because there had been a failure to comply with the option. He was noting, but going no further than that would be subject to the proviso in section 42.2. But he was not making any determination, and that would be surprising if he did so, given that the point wasn't an agreed issue before him, and he had heard no submissions on it. And of course, what we do know is what he then says in Judgment 2, at paragraph...
Just before you come to Judgment 2,
Lord.
can I be sure I've understood your submission on what he's saying in this paragraph, which I have to say for myself I don't find very easy to understand. You said that he was recognising that Julie had rights under section 42, and I think you then said, because there had been a failure to comply with the option. Are you saying that the judge had concluded that at this stage?
Well, the judge is saying she is entitled to post-dissolution accounts under the provisions of section 42.
Under section 42?
Yes.
If he'd stopped there, I would have understood what he was saying, and then he would say, all that's got to be decided. But when he goes on to say, subject to a statutory proviso in section 42.2, including a share of profits and the use that Simon Allison have made of the assets, I thought I understood you to be submitting he'd decided that they had failed to comply with the option, so that section 42.2 didn't exclude their rights.
No, he hasn't gone that far.
Yeah, that's what I was querying, because I think your overall submission is he hasn't really decided any of this.
No, as we've already seen at paragraph 142, he has recorded there has been a failure to exercise the option.
Not to exercise, to.
sorry, to comply with complete the option contract.
Yes.
142, he's recognised that, and he says his explanation is that Simon and Alison are well aware they're unable to raise sufficient funds. So he's recorded that at 142. He's then at 232 gone no further than recognising that Julie has rights under section 42, and Mr. Dumont appeared, I believe, this morning to accept that, because he says Julie is entitled to post-dissolution profits. So post-dissolution accounts
But
under the provisions of section.
Post-dissolution accounts, it's not the same as post-dissolution.
No, it can be both, subject to her election.
Well, no, post-dissolution accounts is the right to have an account. No account has been drawn up. She's entitled to a post-dissolution account. That doesn't say anything about what goes into the account. It just says you're entitled to have the figures drawn up.
No, but the section 42, the post-dissolution accounts under section 42 can either be the interest or an account of profits. Can't be anything else.
Well, what does he then mean by saying subject to the statutory proviso in section 42.2? Doesn't he mean, but I'm not deciding whether that proviso...
No, he's not. He's not heard any argument on it at all.
So what you're saying is that the judge is simply saying there is she's entitled to the post-dissolution accounts under section 42. I haven't heard argument. I haven't not making a decision, but of course her entitlement under section 42.1 will be dependent on whether or not she falls foul of 42.2.
Exactly. Yeah. Exactly. And that is underscored, we say, by two things. One is the making of the April order itself, which is surprising in its terms,
So
if in
recital
fact
3.
he had made the determination that my learned friends say he had.
So you say that ties in with recital.
Exactly. The judge did not make a determination, otherwise why would he have approved that order that records that my client had elected but it was disputed and then gave a direction for the determination? He would not have done so. And it is further underscored by paragraph 35 of the second judgment.
Yeah, but he says he didn't decide it.
Exactly.
Can I just go back to something you were telling us about a little earlier on? Paragraph 142, judgment 1, on page 167. You have already told us that this is where the judge is deciding that Julie has accrued rights. And you pointed to the sentence in which the judge says, I'm satisfied that the underlying explanation is that Simon and Lewison, quote, are well aware, unquote, they will be able to raise sufficient funds to complete. But he also finds at 204, page 188, that the decision to serve the option notice was made in a state of panic without appreciating the consequences. And then he says they now appreciate they don't have sufficient funds to complete the purchase of Jennifer's share, if calculated in the way that the 2012 partnership deed requires. So he seems to be not exactly hedging his bets, but he is certainly finding that they now appreciate they can't pay in accordance with the terms of the 2012 deed. I'm not quite clear he's saying anything more than that.
I think he's accepting there's a failure to comply, and on the evidence that he was available to him, he's made that. But going back to what I say, so we squarely say that he did not determine the issue that my learned friends say he did by reference to 232, and what is said there in relation to section 42. The only other thing I ought to point out as a matter of fairness in relation to what my Lord Justice Lewison has just said, and I'm just reminded of this, is what he says at paragraph 37.
Of judgment 2.
Judgment 2. page 213. He's dealing there with the wording in 42.2 as to compliance in all material respects.
Yeah.
And then he says at the end, had this been a live issue, it is difficult to see how, following their unexplained delay, upwards of 5 years prior to trial, in taking any meaningful steps to complete the option, Simon and Allison could be shown to have complied with it in all material respects.
Well, yes. I think that there is a bit of a difficulty with that, if I may say so. I'd like to hear what you say about it, because in his first order, at paragraph 6, he talks about determining the rights of the parties, and he says that they should be determined as if at the end of clause 15.1.2 of the 2012 deed the following words were inserted, and he sets out the proviso. And he has already said in his judgment that that proviso is to have retrospective effect from the commencement date. See paragraph 212. So how could Simon and Allison have complied with the terms, if you like, when the judge has decided that this proviso needs to be inserted with retrospective effect?
Well, but that is, he is doing that, but that is still within the same order. He's still keeping over the issue of our rights.
That I understand.
And in my submission, there's nothing stopping him from making that proviso, but still awarding interest to take into account what had happened over the last 6 years. Otherwise, we're rewriting history. They have sat there, they've enjoyed the benefits. The estate and Julie have had nothing. And what he is saying is that the proviso has retrospective effect. He does not say at any point that I'm going to give the option with retrospective effect. Now, one of the submissions I was going to make later, I'll make it now, is that if in fact you are with my learned friends with respect to the making of the order, then in my submission that, and we say you shouldn't and that the appeal should fail, but the alternative provision is to find that he had not and did not expunge the rights that had already accrued between the 8th of May 2015 and the making of the April order. Interest had accrued until that point, and therefore Julie is entitled to interest until that order is made.
Is that in your respondent's notice?
My Lord, no, it isn't.
It's a completely new way of putting the case. On the hoof.
That is an argument that look, I'm not allowed to run that argument. That seemed to me I was considering further submission of it today. But we do say that you are entitled to give interest at a different rate in the equitable jurisdiction.
Yes, I follow that.
And so what you could find is, if you're with me on that, is you could say, well, we are going to give you interest, but we're going to cut it off at the date of making of the order.
Sorry, there are two distinct points here.
Yeah.
One point is, maybe, Julie had an accrued right to interest. Yeah. And that right was not expunged by the judge's order, and that accrued right was a right under Section 42 of the Partnership Act.
Yeah.
That's one possibility, which is, as you accept, that's not an argument that you have raised so far.
We have always said that it was an accrued right. That's always been in our skeleton.
The second possibility is to say, well, we should, in the exercise of the equitable jurisdiction, make an order giving Julie the equivalent of 5% from some date until the judge's order, which created the option, as you put it. They're two different
Yeah.
points. One is an accrued statutory right,
Yes.
and the other is an appeal to the equitable
Yes.
discretion.
We have always said, and it's in both the substantive skeleton and it's in the respondent's notice and it's in the skeleton support of that. We have always said that Julie had accrued rights that were never expunged.
Yeah.
So that has always been before this court. What we are saying to you is that if you are right as to the effect of the order, we are saying that the order, if it did have an effect on those rights, did not apply retrospectively. I then, by way of the new ground, I am inviting you to invoke the equitable jurisdiction, your powers that I've already indicated previously. Now, what in fact, I think I've covered all the factual points I wanted to pick up on. What in fact you are being asked by Simon and Alison, you are being asked, they are seeking to argue that the entitlement to interest under section 42 was determined against Julie without any argument and despite the fact that the estate had been kept out of the share of its partnership assets since 2015, whilst the appellants had continued to enjoy all the benefits. Now, I said earlier that I'm not seeking to amend the April order because we say there was nothing wrong with the April order. The April order expressly dealt with the issue of section 42. And although it doesn't expressly refer to the equitable jurisdiction, there is the point that is said about Judge Halliwell being functus officio is wrong. There was nothing stopping him from, at trial 2, saying, well, I'm not giving you section 42, but I'm going to give you interest under the equitable jurisdiction, because he'd recognised at trial 1, in his judgment at trial 1, when he fashioned the remedy of the extended option, that Julie had rights under section 42.
Well, did anyone put that to the judge?
No, the issue wasn't taken. This is completely unforeseen. The point was argued about section 42 was the issue.
But I mean, did anyone say, as you're now saying to us today, but judge, if you find against us on section 42, don't forget you made this a proprietary estoppel case, that was your finding, and therefore you can extend your equitable jurisdiction to go down a different route.
No, the issue was squarely section 42.
No, but it could have been argued on your behalf.
Well,
or lay client's behalf, I should say, that as a backstop argument, which is exactly how you're asking us to treat it now.
It's completely unforeseen consequences. It's unforeseen by everybody, including the judge.
But why is it unforeseen?
Because the situation was that we had got accrued rights. There was an argument on section 42.
Yes.
And it's the interplay between what is said now about the April order and section 42. It is now said, as a result of the April order, the extended option bars section 42 out and in effect gives rise to no interest at all. That is what.
Why is that unforeseen?
No, exactly.
The judge recites that Julie's entitlement to interest under section 42 is disputed.
Yeah.
You agree that he hasn't decided anything about that. So it must be foreseeable, if not hoped for, that he would decide in Simon and Alison's favour on that point. That must have been foreseeable, otherwise he wouldn't have had an argument about it.
Well,
so why is it not foreseeable that the judge would decide that section 42 didn't apply or was excluded by section 42.2, leaving you with nothing unless you put forward some alternative basis for him to exercise his discretion in your favour?
well, the matter wasn't foreseen. It wasn't argued. But we say that does not stop this court from taking the issue now. And we say that the court should deal with that The number of points picking up on that. Firstly, of course, going back to Guest, the Supreme Court have confirmed that the court should be flexible in seeking to do justice between all parties and to seek a pragmatic solution. I've already submitted that this court has the same powers in relation to this appeal as the lower court has, and that would have included the right to vary the September order or to deal with the equitable interest point. And if this appeal succeeds, then what is the situation is that Julie will be left with no interest, if my learned friends are right, notwithstanding that they've enjoyed the benefits of this partnership assets since 2015, and notwithstanding that had they sought to pay by instalments, which is in effect what the judge has given them, they would have had to pay interest at the Barclays Bank-based lending rate.
Do you agree with Mr. Dumont that that would have produced a very much lower figure?
The figure is, and the schedule that we sent to my learned friend, I think, filed at court earlier, the figure is actually slightly reduced because my solicitors didn't take into account the issue with Pheasant Lodge. Up to today's date, it's 102,657.39. So yes, it's substantially less.
I was a bit puzzled by the interest calculation, which starts on the 8th of November 2015. I wasn't sure.
That's 6 months after.
Oh, that's 6 months after the date of dissolution, is it? Yeah.
Yes.
Yeah, I follow.
So I accept, my lords, yes. But and what I do say is that so going back to addressing the Denton argument, we say in all the circumstances when we are looking about an equity, here is a situation where there was a failure to comply. There was a situation where Simon and Alison dishonestly sought to keep Julie out of.
I mean, you've both had your moment in court for the sake of your late clients, to read out the findings that the judge made in respect of each party's behaviour. I think we're aware of it. I don't think when the lay parties are here, we really need to keep going on and on. And these family disputes are deeply distressing, and no one has covered themselves with glory, and I don't think we need to hear any more about that.
You've got the factual matrix. The situation is that whereas the estate and Julie have been kept out, they've enjoyed the benefits, and in all the circumstances, therefore, you should be allowed to make the application and amend. You have the power. I say it's not permission to appeal, you have to do so, and it's right that you need to do so. And I say at the bare minimum, if the appeal succeeds, and I say the reasons that I've not really elaborated on, but you've got to get the skeletons, it shouldn't. But if it does succeed, Julie should get interest at the bare minimum pursuant to clause 18 and the Barclays Bank lending rate. All right. Everything else is in the skeleton. My lady, I apologise if I, by reference to that, I in some way caused offence. It wasn't my, because that's just the factual matrix.
No, it's just one sitting here, one can see both sides of the family.
Indeed.
And both of you had taken the opportunity to read out most pejorative parts of the judgment in relation to the other side, and I just thought we'd probably heard enough.
I'm grateful for that. Unless I can assist you with further, I make my application.
Right, all right. Well, we're not going to decide it now. You'll get an answer in the judgment.
Grateful. As far as the, I don't know if you need to hear me in relation to the substantive argument.
Sorry, just a minute, Mr. Maynard.
You've got my submissions on that, haven't you? And one of the principal ones, of course, is that we tried to raise this ourselves and were refused permission to deal with it.
Right. All right. Well, why don't you say what you want to say, and then perhaps we will reconsider whether we give you an answer now or later.
Can I just deal with that point? I should deal with that point, then my little friend can hear what we say. As far as that point is concerned, and the finality of orders, well, firstly, we're saying we are not appealing against the April order. We are asking you to vary the September order, and you've got power to do so. So we're not looking at what grounds 4 and 5 of the appellant's grounds were directed at the April order. So we say that they're wrong. The situation isn't comparable. We're saying our new ground is consequential on their grounds of appeal succeeding, and it is about enabling this court to reach a fair decision and to do justice between these parties. Their ground 4 and 5 was framed as a critique of Judge Halliwell's reasoning, which could have been advanced after the April order. And of course, as my Lord Justice Lewison noted in refusing permission to appeal, we've been asking them, are you going to apply to appeal? And they didn't.
Yeah. Right, Mr. Dumont, do you want to say something about this application?
Yes, my Lord, it was that our ground 4, which you find at page 26 in the bundle.
Yeah.
So it was aimed at saying that if we are stuck with 5%, contrary to all our other submissions, that 5% is too much, that it didn't give effect to our proprietary estoppel claims, and we had a whole stream of arguments why that was so. And we were not allowed to run that. So we have come here stuck with, unfortunately, the binary of 5% or nothing, and having been ourselves refused that at the early stage of this application, you should refuse the same application made now. I mean, and friend, which is just essentially just the other side of the coin.
Yeah. Right, you've got it. Do you want to say anything more,
No,
Mr.
you've got my point.
All right. Well, we'll adjourn now. We'll sit again at 10 to 2.